Hello. The next topic which we are discussing today is a specific relief act of 1963. Before going to the specific relief act, we must have a brief history as to how the specific relief act came into existence. The great grandmother of the entire commercial law is the Contracts Act, and the Contracts Act was passed in 1872, whereby the Contracts Act contained within itself the general principles of contract, that is from section 1 to section 75, and thereafter we have got a lull from 76 to 100, where then we have got the specific contracts which are dealt with from section 120, section 115 or 116 to the end. That is indemnity guarantee, bailment, and agency. That's how the Contracts Act was made up. Then we had also in the Contracts Act the Indian Railways Act, the Carriers Act, Negotiable Instruments Act, then the Specific Relief Act, then we have got what is called the various commercial laws. Then the English people felt that it was a very verbose enactment and which has to be emasculated and divided into various parts. And first time, the Specific Relief Act was removed from the Contracts Act, and the Specific Relief Act was passed in 1908. And after that, it underwent amendments, and the new act which we are following today is the Specific Relief Act of 1908 as amended in 1963. So the Specific Relief Act which is now implemented is the Specific Relief Act of 1963. Before going to the Specific Relief Act, we must know how the Specific Relief Act came into force. Previously, in England, the courts used to come into existence only by a charter issued by Her Majesty, the Queen of England. And the first courts which were established in England or UK was the common law courts. They were called common law courts, Court of Exchequer, Court of Common Pleas, and uh, Court of Common Pleas, etc. As far as Court of Common Pleas were concerned, they were dealing with all money matters, and as far as Court of Exchequer is concerned, it was dealing with financial matters, and Queen's Bench or the King's Bench used to discuss about other matters. Then what happened was, please remember, now all of you know, you make an agreement not for the fun's sake. You want an agreement to be made so that both the parties may implement the agreement both in the letter as well as in the spirit. The common law courts, whenever a suit was filed for enforcement of a contract, the common law courts used to shut the doors and say money compensation alone used to be granted, and they used to wipe the tears of the victim by paying money compensation plus interest. Then, as far as injunction is concerned, now you know you got injunctions. Here, the negative aspect, you cannot prevent a person from committing a breach of contract. Negative aspect was not enforced by the common law courts. Slowly, what happened was discontent spread among the litigant public because they make an agreement to see that both the parties follow the agreement in the letter as well as in the spirit. Then what happened was lot of petitions were filed before the Queen of England to dispense justice. Here, as far as the equitable principle is concerned, justice should not only be done but deemed to be done. When you have an agreement of sale or whatever it is, you must have a methodology through which the agreement has to be enforced, or you must have a methodology from which through which you can prevent the other side from committing a breach of contract. So they initiated various doctrines which came into force, and slowly what happened was people started flocking to the equity courts. They are called equity courts. And the Lord Chancellor, who is now now they are called Prime Minister of UK, he was the conscience keeper of the Queen. You know, at one stage, UK was almost ruling two-thirds of the world. They had colonies throughout the world, including our own country. So what the Queen felt was she had to deal with a lot of administrative problems and ruling problems, and she delegated her functions to her conscience keeper, that is the Lord Chancellor. Lord Chancellor is now called the Prime Minister of England. Then the equity courts came into existence on the other side of the Westminster Palace, and they used to dispense justice according to three basic principles: justice, equity, and good conscience. Justice is insaf, equity means barabari, and good conscience means sainiyati. And whenever trust and confidence is reposed in a particular person, and the other person who reposes the trust and confidence trust the other person completely, surrenders himself, you must have a methodology through which the agreement is enforced in a court of law. That is the reason why they evolved the doctrine of what is called specific performance. And then you must also prevent the other side from committing a breach of contract or violating the terms of the contract, and that's how injunctions were developed. And they also developed various doctrines like void contract, voidable contract, illegal contract, unlawful contract, contracts opposed to public policy, wagering contract, cancellation and declaration, and also injunctions also were incorporated in the specific fact. Then normally, Savithigola Modalaina. So what happened was the crowd in the common law courts diminished, and this equity courts grew in wide proportions, and people were flocking to the equity courts to get justice, and that's why the equity courts. Then there was a dispute between the chief justice of the common law courts and the equity courts, who is superior and who is not superior. Then the matter was referred to the Queen for adjudication, and that was the famous case of Addington versus Chief Justice Coke. Chief Justice Coke was the Chief Justice of the Common Law Courts, and Addington was the Chancellor who was delegated with equity functions. Then the matter came up before the Queen for redress, and the Queen held it in favor of the equity courts and said, equity courts have not come in to destroy the law, and whatever defects are there in the common law courts, they used to supplement it and see that justice is not only to be done, but also deemed to be done, so that the tears of a person can be wiped out that way. And that's why the verdict was given in favor of the equity courts, and common law court said, you are no way inferior, but you have got your own jurisdiction. But you must have a methodology through which a contract is not only implemented in the letter as well as in the spirit, and there must be a mechanism through which a person cannot violate the terms of the contract. Then they developed the doctrine of what is called void contract, voidable contracts, contracts opposed to public policy, wagering contracts, cancellation of decrees and instruments, declaration decrees, then injunctions, so on and so forth, and rectification especially was developed by the equity courts. In civil law, here in India and all, we call it a summons, isn't it? When you file a suit, summons go to the other side. The other side has to be present in the court on a particular day at a particular time assigned to it. Here, the equity courts developed a doctrine called subpoena, S-U-B-P-O-E-N-A, subpoena. Subpoena is more drastic than summons. The opposite party is brought physically to the court and asked to answer the averments made by the complainant, and redress was made in a summary and cursory manner. And please remember, you may ask me a question, sir. Suppose a person is not present when a subpoena is issued, his property will be attached, he'll be bodily brought to the court and asked to answer the question. That was the power of the equity court. Then, yes? It is still continuing, right? Yes. Then subpoena, then after that, what happens is, here what is important is trust and confidence. There is an agreement. which has to be implemented, which has to be followed in the letter as well as in the spirit. Court should not be helpless in redressing the grievances of a party. That's the reason they evolved the doctrine of subpoena. I'm sorry, specific performance. Then they also said a person shall not violate the terms of the contract. That's why injunctions were born. Injunctions was born. Here I would like to make a distinction. I find some advocates writing in the plain that they write injection. Please remember, different professionals have different meanings and different connotations. As far as a doctor is concerned, he knows only one thing called injection. As far as an advocate is concerned, he knows only one thing called injunctions. INJUNCTION. Here, this is the history of how the equity jurisdiction developed. In India, we do not have a separate law of equity. In India, we do not have a separate law of equity. But equitable principles are found almost in every enactment. Most of you know about it. For example, if you see specific performance of the contract is found in the specific relief act. It is an equitable principle which is borrowed from equity codes. Injunction is a principle borrowed from equity codes. That is called injunction. Cancellation, declaration, rectification, rescission, contracts opposed to public policy are all children born out of equity. Though you don't have a separate law of equity, equitable principles are found in almost every enactment. Suppose you are aware of the Transfer of Property Act. There also, what is called, there is a doctrine called nemo dat quod non habet. That is 37 to 40 of the Transfer of Property Act deals with that. No man can pass a better title than what he himself has. Right? Then you got sale by ostensible owner or sale by holding out. Then you got what is called the equitable principle called feeding the grant by estoppel. They evolved the doctrine of estoppel also, where your mouth is shut, where you make a particular representation, particular assertion, you will be compelled to make good that assertion, compelled to make good the representation. That is, and later on, your mouth is shut. You cannot take a contrary stand. It is only the prerogative of a politician who says something today and tomorrow he comes on record to say, I was misquoted. This is what is reality. We find it only in politics, but in law we don't find it. Then you have got one more section in Transfer of Property Act, section 109, where they say, suppose you have been inducted into possession by a person having no titles. Let us put it this way. He has got a defective title. You cannot assert or cannot set up an adverse title in your rival and say, both of you fight, and whoever is a successful party, I will perform my obligations. No. When you have been inducted into possession by a person having no title, let us say, you have to obey that person. You have to pay the rent to that person. You have to perform your obligations as far as that person is concerned. You cannot set up title in another person and then say both of something like two cats fighting and the monkey getting benefited. No. That's why it is called promissory estoppel that has been embodied in section 109. Then cancellation. Suppose the document is void or voidable, whatever it may be, that document, if it's allowed to remain, it is going to cause prejudice to you, damage to you. Then you can get that document cancelled under due process of law. Then you have got declaration. When a position, character, cadre, or something is asserted by you and it's denied by the other side, you can get your position, get your cadre, or get your thing adjudicated by court, declared that you are the rightful person. Then you have got injunction. You can prevent the other side from committing a breach of contract by approaching the court under section 38 to 40 of the specific relief act, ask for injunctions. Then there are certain reliefs which cannot be granted by the equity court. That is what section 41 of the specific relief act. So this is the breakup. And then you have got one more thing. Suppose a person is dispossessed other than by due process of law, within 6 months from the date of disposition, he can approach the court by filing a suit and a summary nature, ask for being put back into possession what he was before the wrongful act was committed. Then you've got contracts opposed to public policy. Will come one by one. So the brief history or the specific relief act or the introduction to the specific relief act. First and foremost is the reliefs under the specific relief act previously was a discretionary remedy. It is not available to you as a matter of right or what is called UB jus, EB remedium. Wherever there's a right, there is a remedy. But you have to come within the two basic principles of equity. One who comes to equity must come with clean hands. One who seeks equity must do equity. These are the two basic principles which governs the law of equity as far as the specific relief act. I'll discuss it in detail when we come to the topic. Yes. Now we come to the alphabets of the specific relief act contained in section 2 of the specific relief act. The first term that is defined is what is called promisor. Promisor is a person who promises to do a particular thing at a particular time covered by a document is called the promisor. And the person to whom that promise is made is called the promisee. Right? Third one is capacity. Capacity means under section 11 of the Contracts Act, any contract with a minor, insane person, idiot, or otherwise disqualified by any law for the time being enforced is void ab initio, right from the beginning. Then next term that is defined is consideration. Consideration is defined not in a specific relief act, but here also we have that is the recompense for the promise made is what is called consideration. Consideration can be money or it can be in kind or it can be by any services that is rendered. Or consideration to be proper under section 2D of the Contracts Act says any that is consideration means any forbearance, abstinence, or to do a particular thing or not to do a particular thing is called consideration. And you know, under section 2D, any contract without consideration is a nudum pactum and it's a nullity and cannot be enforced. Then, of course, you've got exception also to it. Section 25 of the Contracts Act says that even paying a time-barred debt, promise to pay a time-barred debt, promise by way of an acknowledgement, promise by way of correspondence is also good consideration. That's what section 25 says of the Contracts Act. Now we come into the specific relief act properly. Here, the first section which I will deal with is section 6 and section 7 of the specific relief act, where it says that a person who is in rightful possession, lawful possession of the property has been dispossessed other than by due process of law. He has got facts, he has got documents, he has got everything to prove and establish his occupation or his right to the property. Then under section 6 and 7 of the specific relief act, he can always file a suit to be put back into possession of the property which he has lost because of the wrongful acts of the other side, and within 6 months he can file a suit. That is under section 6 and 7. And what all you have to establish under section 6 and 7 is that you are in possession of the property, you have got the documents in your favor, you are a rightful possessor of the property, the electricity meter stands in your name, water connection stands in your name, gas connection stands in your name, or you have got voter ID which says that you are in possession of the property. All those things you'll have to prove and establish before the court that you are in possession. Then, in case you have been dispossessed by the defendant through illegal process or through the mafia, then you can ask the court to put you back into possession by filing a summary suit within section 6 and 7 of the special. Please remember, under section 6 and 7, a decree passed under section 6 and 7 is not appealable, only a revision can be filed. It is not subject matter of an appeal. Am I making myself clear to you, please? Then we go to the longest chapter as far as the specific relief act is concerned, called specific performance of the contract. That is from section 9 to section 24 of the specific. Here, whenever there is an agreement, understanding between both the parties and all the elements of the contract is present: offer, acceptance, consideration, capacity, legality, consent, legality of object is concerned, as laid down in the Contracts Act, under Section 6 of the Contracts Act, court should not be helpless in implementing that agreement in a court of law. And what all you have to prove in such a contingency is, sir, there is an offer made by a particular person. It may be a specific offer or it may be a general offer. I have complied with the offer. I have accepted the offer. I have communicated the acceptance. Acceptance has reached the offerer, and the offerer is not trying to implement the contract. Please compel him to implement the contract. So, all the basic ingredients of the Contracts Act, like offer, acceptance, capacity, consideration, then consent, legality of object, will have to be laid down, will have to be established, will have to be proved. In this case, I would just refer to a case in the Contracts Act, a famous case of Carlyle versus Carbolic Smoke Ball Company's case, where an offer was made to the general public by the Carbolic Smoke Ball Company, saying that anyone who is who is affected with influenza, or what you call it as flu, uses the carbolic smoke ball manufactured by that company for a period of 2 weeks and still affected with influenza, can claim a reward of 500 pounds from the company. It was a general offer. Any person from the public. This poor lady Carlyle, like you and me, was affected with influenza, not COVID. The question is, then she used the carbolic smoke ball as per the offer made by the company for a period of 2 weeks. Still, that influenza was not cured. Then she brought an action against the carbolic smoke ball company, claiming the reward of 500 pounds. The carbolic smoke ball company raised a defense, sir, no doubt an offer has been made. It is not a specific offer. I have not made an offer to Carlyle, but it was made to the entire general public. And even though Carlyle might have accepted it, there is no privity of contract between my company and Carlyle. But the courts in this case said is, when an offer is made of a general nature, any person from the public who comes forward and fulfills the terms of the offer according to the printed instructions is entitled for the reward. So in this case, Carlyle was allowed to recover that 500 pounds which was offered as reward. So what I'm trying to tell you is, an offer need not be made to a person specifically. It can be made to the entire general public. But any person from the public who comes forward and fulfills the terms of the offer is deemed to have accepted the offer, and it's a binding contract. So that can be implemented. Are you able to understand, please? Then one thing is this: you got specific offer. Specific offer is, I think most of you are appearing for interviews and all, or written exams or certain posts. Let us say 50 posts are offered, and out of 50 posts, let us say 15 posts are for scheduled caste, 10 posts are for scheduled tribes, 10 posts are for BCs, 5 posts are for ladies, and other 10% is for the general category. Then, suppose I belong to the general category and I want a post of the assigned to the scheduled caste or the scheduled tribes, I cannot get it. Or let us say the advertisement says only scheduled caste and scheduled tribe candidates need apply. That means as a person belonging to the original community, I cannot apply because I am not eligible for that. Then age criteria is also mentioned, not above 35 years. That means I should not cross 35 years. So when certain criteria is mentioned, when certain conditions are mentioned, then those conditions have to be complied with. Whether you are eligible or ineligible, that has to be established first. That is called a specific offer. Then specific offer also, I can give you one more example. Suppose let us say tenders are there. Then suppose tenders are made, it is a general offer. It is not made to one person or two persons. It is made to the entire general public. You can submit your tenders, give your quotations, but you cannot guarantee saying that you should be given the contract. No. If you are the successful tenderer, then alone you are entitled to it. Or let us say the tender is given only scheduled caste and scheduled tribe people need apply. Then in that case, only people belonging to that community can alone apply. And nowadays, I think everything is online except marriage is not online now. You cannot choose your bride. I think that also is available. Telugu matrimony, general matrimony, that matrimony, Kapu matrimony, that and all. The question is, that means you must belong to that particular. You need not go on that now because people are marrying whosoever they like. The question is their choice. No one can compel anything. But the question is, if it's made to a specific to a specific group of persons or person, only that person belonging to that particular group shall apply for that particular post. That is called a specific offer. Or suppose, let us say, I make an offer to you. You alone has to accept it. And I say the mode of acceptance is you must accept it online, not personally. Then I have to give it by online and then accept it accordingly. In this regard, I would cite a quotation. That is, it is always said it's popular. The first quotation which a lecturer on contracts lectures about is an acceptance is an offer. What a lighter match is to a train of gunpowder. That means, suppose this is the tray, in the tray gunpowder is kept. Then let us say, so long as it is not ignited, so long as a matchstick is not lit, it remains a gunpowder. But once you light a match and then there is a big explosion, nothing can be lit. What remains is only good. Only the tray will be empty. So that is the effect of acceptance. So that's why it is said, an acceptance is to an offer what a lighter match is to a train of gunpowder. Then how acceptance has to be made, how it has to be communicated, how it has to reach the offerer, and what is the mode or methodology through which it is done, it will be specified in the terms of the offer itself. So you will have to conform yourself to the terms of the offer and do it accordingly. And once an acceptance reaches the offerer, an explosion takes place, an agreement is made. And that agreement, which is enforceable in a court of law, is what is called a contract. Am I making myself clear to you, please? Then, a contract has to be distinguished between an invitation to offer and a contract. Now, before going to that, all contracts are agreements, but all agreements are not contracts. The leading case on that aspect is the case of Balfour versus Balfour, Balfour versus Balfour. In this case, what happened was the husband was working in UK and both the husband and wife were living together happily. It so happened that the husband got transferred to Sri Lanka or Ceylon those days and found greener pastures and left the wife. But before saying that, he said, don't worry, my dear wife, I will be sending you 400 pounds every month towards your maintenance. Then what happened was, once he found the greener pastures, he forgot about this wife. Then the wife brought an action to enforce the contract by saying, the husband promised me 400 pounds, so long as we are living separately, please enforce that agreement. Here the court said, it is not an agreement which gives rise to legal complications or legal interpretations. It is only a social agreement between the husband and the wife. And since it's only a social agreements cannot be enforced in a court. So no specific performance can lie. Suppose, let us say, I invite you for a cup of tea or snacks in my house for a break. I invite you for a breakfast. On that day, let us say, I'm down with fever. I'm not able to arrange it. You cannot file a suit and say, sir, because this man invited me for a breakfast, I told my wife not to cook anything. My friend will get it. And on that particular day, let us say, because of my inability, I'm not able to keep up my word. That person cannot file a suit against me by saying, you made me starve the whole day because of not providing me breakfast. Please now provide me breakfast. Or that agreement has to be specifically enforced. If that is going to be specifically enforced, what would happen is none of us will invite anyone for lunch Anyone, none of us will invite anyone for dinner. None of us will invite anyone for breakfast also. So the question is, they are all called social agreements. In a society where we live, in a society where with the society, సమాజంతో మనం కూడా జీవిస్తాం. The question is, we have social responsibilities also. Not because the question, we invite a person for a wedding, we invite a person for a dinner, we invite a person for a lunch, we invite a person for a breakfast, doesn't mean that that person does not have anything. He's begging on the street. No, we have to keep up some social commitments also. But certain contingencies arise where we are not able to keep up our word. They are all called social agreements. And social agreements are not enforceable in a court of law. Only those agreements which gives rise to legal obligations, which is enforceable in a court, or where the parties desire, in case of any violation, in case of any breach, they have to be attended by legal consequences. Only those agreements are contracts. But all contracts are agreements, but all agreements are not contracts. You have to follow this. So this is the brief of the contracts are coupled with specificity. After all, specificity fact is nothing but a child born out of contracts act. The contractual principles apply as far as specific relief also is concerned. Then you have got the equitable principles again in the Transfer of Property Act. If I am correct, it is section 43 of the Transfer of Property Act. It says that is what is called. Pardon? No, no, not customs law. Feeding the grant by a stepper. On the day when I make a contract with you, I don't have title. But subsequently, I acquire title to the property by some mode, let us say. The subsequently acquired title perfects an otherwise imperfect grant, imperfect transfer which is made on the day when I have a defective title. I will be compelled in a court of law to make good that representation, and the subsequently acquired title feeds an otherwise defective title. That is what is called feeding the grant by stepper. And you, as a making the person making the promise, you will be compelled, you will be stopped from making a different assertion than what you have made. That is section 43.
Sir, the guarantor is not getting any consideration from the beneficiary. Because somebody is taking loan, I am giving a guarantee. I am not getting any consideration to this agreement. So is it a valid?
It is definitely valid. The question is, when you are a guarantor, consideration or no consideration, the question is whatever you have paid on my behalf, let us say, to the company or to the bank or whatever it is, you have got a right of filing a suit for contribution. That money which you have paid, you can get it reimbursed. You get substituted in the place of the original creditor and then recover that money which you have paid on behalf of the debtor.
But the beneficiary is getting loan from the bank.
Maybe, but still you have assured that payment.
Yeah,
In case
I sure, but I didn't get any consideration to that.
that is not the criteria.
Sir,
And
here, three guarantees are there. So three will be
jointly and severally liable
jointly. So the amount will be recovered
from any one of them or
Any one of
Not
jointly.
equally or proportionately, whatever it is possible.
Proportionately,
So if you are
Nikado, I can recover anything from anyone. I can recover from all the three people also. But the money which you have paid on behalf of the debtor, you are entitled for contribution. You are entitled to bring a suit on behalf on your own behalf and then recover that money which you have paid to the creditor. You get substituted in the place of the creditor. Not exactly subrogation, it's called contribution. Since you have raised the topic of subrogation, I'll deal with that. Subrogation is under section 92 of the Transfer of Property Act, which says that now marine policies are issued. That is normally contract of insurance. It's normally between the consignor and the consignee, isn't it? But here the carrier also comes into the picture, where it is signed by all the three people: consignor, consignee, and the carrier. The question is, as far as the insurance company is concerned, they have to pay the entire money which has been insured. But once it pays the money on behalf of the carrier, that money which they have paid
they get substituted in the place of the creditor. Along with the creditor, they can bring a suit against the carrier and then recover that money which is paid. That is the triumvirate contract between the consignor, consignee, and the insurance company and the carrier. I'm sorry. So, in one case, I think since you have raised that topic, I'll also deal with that. In one of the cases, a suit was brought by the New India Assurance Company against Jagjit Transport Company at Jabalpur. They joined hands with the ECIL and brought the suit because ECIL was a consignment. Then what happened was the chemicals were being carried from Raipur, that is now in Chhattisgarh, to reach Hyderabad. Then on the way, what happened because of the bad roads and because they were carrying chemicals, 20 drums of chemicals were there. Out of 20 drums, four drums got damaged. 16 drums were intact. Then the insurance company held an appraisal, and at the first appraisal, the carrier was present, and they found that only 4 drums were damaged and 16 drums were intact. And in fact, the consignee used those 16 drums, sold it in the market. Then the insurance company, in collusion with the consignee, paid the compensation for the entire 20 drums. And they said the compensation which is paid for and on behalf, because of the negligence of the carrier, they are entitled to recover that money what they have paid. They get subrogated in the place of the consignee. Then I was appearing with the transport company by saying, sir, 16 drums were intact, 4 drums were damaged. At the most, the damages can be claimed only for 4 drums and not for 16 drums. And second appraisal was held where they wanted to cover up their lapse by saying all the 20 drums were damaged. Then the court took the view saying that the carrier has to pay only for the 4 drums and not for the 16 drums. Then my carrier company said, because he was a Sardarji, Munafa Peskin, that's appeal. Appeal was filed. At that stage, the insurance company came to the knees and said, sir, pay whatever you want. And we paid only for the 3 drums and the matter was settled. So what I'm trying to tell you is, especially in subrogation means where you get substituted in the place of the original person concerned. But contribution is when you pay the money on behalf of the debtor and clear the debt, you step into the shoes of the creditor and then recover that money which you have paid on behalf of the principal debtor to liquidate the debt. That is called right of contribution. Anyway, now we come to section 9 to section 24. First and foremost is any contract, any agreement which fulfills the terms of the Contracts Act can be enforced in a court of law. Right? Then section 10 says a suit can be filed to enforce the contract. A suit can be filed to enforce the contract, provided there is an offer, there is an acceptance, there is a consideration, there is a consent, there is what is called legality of object, so on and so forth. Then section 11 goes further by saying who can file a suit, who may sue. You got in the Contracts Act, there's a maxim called privity of contract. Contract binds only privies to the contract, or contract binds only parties to the contract. A stranger to a contract cannot sue on the contract, isn't it? That's the basic principle. But here it says after the demise of the contracting party, his legal representatives, his transferees in interest, his executors, his administrators, or assignees in interest, they can file a suit on behalf of the deceased person. So they are all persons eligible to file a suit and they can sue the opposite side. Right? So privity of contract doctrine does not apply in such contingency. That's what section 11 says. Here, one important thing you must remember is section 10 originally specific performance was only a discretionary remedy. If you see the word, the court may, the word may is used. Lot of emphasis is given on the word may. But in 2018, this particular section was amended, whereby the word may is removed and the word shall is imposed. Shall is. That means once a suit is filed for enforcement of a contract, the court shall, not may, court shall decree the suit. The word may is discretionary remedy is removed now. Discretionary remedy is no longer there in the statute book. The word shall. That means it is mandatory for the court to decree the suit, provided all the ingredients are satisfied. Are you able to understand this? This particular amendment was brought forth in 2018 by amending section 10, whereby it says the word may is substituted by the word shall. Shall is obligatory. It is mandatory for the court to decree. And once an agreement is set forth before the court shall presume that it has been properly done, it has been done according to formalities, and the court has to decree the suit. It is mostly tilted more towards the plaintiff. Then you have got certain agreements which are not enforceable. Where specific performance cannot be granted. Suppose you have got an adequate remedy, money compensation is sufficient to redress the wrong which has been done to you. Or, I put it this way, suppose professional skill is required to perform a contract. Suppose you go to a surgeon, ask him to perform an operation for your ulcer or appendicitis. On that particular day, to your misfortune, that surgeon gets a stroke. He is unable to perform the contract. Then in that case, you cannot say, please come from the ICU, perform the obligation, and then go away to your ICU or to your graveyard, whichever is necessary. You cannot compel him to do it. But if you accept performance from his juniors under the supervision or the guidance of the senior, you cannot complain of breach of contract. Suppose, I think this gentleman is here. Suppose, let us say, he's a senior advocate in Jatial or whichever place it is. The client comes to you because he has got confidence on you and he believes you in your integrity, your skill, experience, and all. Sometimes it's not possible because, please, after all, we remember we are all mortals. We are not going to remain healthy all through. Then we have a band of juniors with us. Juniors are sometimes more intelligent than seniors. Ati teli untudannam. The question is, suppose the client says, sir, మీరు చేస్తే చేయండి, లేకపోతే మీ జూనియర్కి మీరు ఇన్స్ట్రక్షన్స్ ఇచ్చి సూపర్విజన్ మీద చేయించండి, నాకేం అభ్యంతరం లేదు. When you accept performance from the juniors of that particular doctor or the surgeon, you cannot complain of saying, sir, only that surgeon should have done it, not the juniors. So the question, that's why the doctors, what they do is they take an agreement. I have no objection for the operation being performed by the juniors of Dr. So So it applies in various fields. Your advocate's profession also is like that. In my office, we have got juniors here. Sometimes what happens is not possible for me to attend all the cases. But there are certain skeleton cases also. This man's case, where I have to be personally present. The question is, అందుకే అంటారు ఎక్స్పీరియన్స్ తోటి మీరు అబద్ధాలు మాట్లాడిన కూడా కొన్ని నమ్ముతారండి. That's why they say a particular judge was remarking, you have got an art of twisting your arguments. That's what I meant for. And there are certain words which I use in my arguments, which the judges to go home and then read it again, go through the dictionary and find out the meaning. And they say, because one advantage, they know that I have been in the teaching profession. వాడు చెప్పేది నిజమే ఉంటుందేమో, నేను చెప్పేదంతా బ్లా బ్లా బ్లా, కానీ అది నమ్ముతారు అనమాట. అదేది మీరు పోయి చెప్పండి, అది కాదండి, ఇది అది అంటే. సో క్వశ్చన్ is sometimes by oratory you carry the day. And first of all, when you have professional service required, expert service required, and that person is mentally or physically incapable of performing the act, you cannot complain of what is called non-performance of the contract. In those cases, specific performance cannot be ordered. Let us put it the other way around also. Let us say on the date of agreement, the property is existing. Subsequently, let us say that under the road widening scheme, the municipality acquires that land for a public purpose. Then in that case, I cannot say a public purpose acquired చేసేది కూడా నాకు అది కూలగొట్టేసి నాకు ఇవ్వండి అని చెప్పి అడగలేదు. Specific performance, only that part of it can be ordered. I will give you one example, sir. Suppose, let us say, a person makes an agreement for 100 bighas or 100 acres of land. 70 acres belong to him, 30 acres does not belong to him, it belongs to his sister. Or it belongs to his sister-in-law, let us say. In Hindi, they say, Sali Adi Garwali. Now it's Sala Ada Garwala because of the present trend which is going on. Here, I got title only to the extent of 70 acres. But regarding the 30 acres, I say that I'll persuade my sister-in-law or sister to part with that land and sell the property to you. Later on, the sister refuses to part with the 30 acres of land. Then I receive the entire consideration for 100 acres. What is a part of it I can perform? I can perform only to the extent of 70 acres. Regarding the 30 acres, I cannot do it because the property does not belong to me. Then in that particular case, instead of striking down the entire contract, what the court does is it directs the other side to transfer the 70 acres of land to me, and that regarding the 30 acres where he has received the consideration, to return that money with the interest of whatever it is. So here specific performance can be granted only to the extent of 70 acres, not to the extent of 100 acres. Are you able to understand this? Then suppose put the other way around. Suppose 100 acres of Buddha, it cannot be severed, it cannot be separated. Where it is, no one knows. Then in that particular case, the entire money has to be returned, and with the interest part of it, specific performance cannot be granted. Where money compensation is sufficient to redress the wrong, then money compensation will be paid or directly to be paid, but specific performance will not be granted. Then you have got section 16 of the specific fact, which talks about more prominently readiness and willingness to perform the contract. Readiness and willingness to perform the contract means at any time the court directs me to pay the balance of the sale consideration to the other side, I should be ready and willing to deposit that money or pay that money to the other side. But I don't have a penny in my pocket, but still I want to purchase a property worth about 3 crores. 3 crores का मूल नया पैसा मूल ना दे ले. The question is, court will not order specific performance because your capacity, your financial solvency, your capacity to pay, your readiness to perform the part of the contract, all these parts will be taken into consideration in deciding a suit for specific. But one important thing you must remember is readiness and willingness has to be specifically pleaded and specifically proved and established. But even that has gone now, where they say under the 2018 amendment, even if you don't plead readiness and willingness, the court can decree the suit if you are able to establish your case. Then, yes, no, then we go to what is called the other sections you need not bother about it. Then section 22. In our High Court, we had a judge by name L. Narasimha, Justice L. Narasimha. I don't call him Justice L. Narasimha because he was my student also. Even now I call him Narasimha. The question is, he says that suppose you file a suit for specific performance, you must also claim an alternative relief. That is, alternatively, if specific performance cannot be granted, for refund of the money, whatever I paid plus interest part of it should be directed to be paid by the other side. Previously, what used to happen is, even if you don't plead, under equity, they can order for return of the money. But now, specifically, alternative pleading has to be there in a suit for specific performance. Unless that alternative pleading is there, the question of decreeing the suit does not arise, or refund of the money does not arise. Right? Then we go to the contracts opposed to public policy. Section 26. Section 26, I think someone was raising the point of Dharani and all this.
Sir, kindly ask.
I'm coming to that. Section 26 deals with rectification of instruments. In this, I put it in a lighter way. Suppose your son comes to you. Every month he has to take your signature on the progress report. Then naturally, as a father interested in the son, you go through the marks card. Your son in arithmetic, please remember, I was also a casualty as far as mathematics. You will get only 30.
But what the son cleverly does is, he makes 3 into 8. Then 6, there are some figures which you can convert. Then 2 also you can make it into 3. 1 also you can make it into 2. Or 1 you can make it into 9. 1 you can make it into 7. That's the reason why most of the people, when they use the word numeral 7, they put a dash in the middle so that it is not altered to 9. So Your son, what he does is, ఆ 30ని వాడు 80 చేస్తాడు. Then 60 వచ్చిన దాన్ని ఏదో ఫిగర్ చేస్తాడు. Then the father is very happy, my son has got so many marks, and అక్కడ ఒరిజినల్ రికార్డ్ చూస్తే ఇదే మార్క్స్ ఉంటుంది అనమాట. So unless the original record is corrected or rectified or altered, the question in the marks remain as it is in the official records, not what is corrected. So here, sometimes so many discrepancies arise in our documents also. Please remember, the document which is drafted by an advocate, document which is drafted by a draftsman, that is the document writer, are entirely different. The document writer believes in what is called cut and paste, copy paste or whatever it is. Cut and again. See, question is copying also is an art. The question is here he has got a format with him. Sometimes స్త్రీలని పురుషులు చేస్తారు, పురుషులను స్త్రీ చేస్తారు. షెడ్యూల్ ఆఫ్ ప్రాపర్టీ ఎక్కడ ఉందా బాబు అంటే 91/A అంటే 91/E అని పెడతాడు. The question is there are discrepancies which arise. Suppose if they say property is situated at Trunk Road, Nellore, then it is not properly described. Nellore is absent from that. Nellore is now called some other district, I think, Purti Sriramulu, whatever, or Kodu Sriramulu, whatever it is. Then Guntur is also called NTR district. Vijayawada is also called NTR district. Here, of course, cluster of districts are there. Telangana, you need not count on that. 34 districts are there without any infrastructure also. The question is, there are certain discrepancies mentioned there, or the document does not speak about the spirit, where it is located, in which the subdivision it is located, what are the Sariyandulu, that is the boundaries, what is the extent of land, or what is the description of the property, description of the persons who have executed and who are claiming that property is not properly described. Then in that particular case, you have to resort to what is called section 26 of the specifically fact, ask for rectification of the instrument. And it's a very summary relief that is normally granted. No court refuses to give a relief of rectification. But the court fee which you pay in respect of a rectification suit is only 15 rupees for each survey number, which you want correction to be made. That is section 43 of the Court Fees Act.
That is per year or all the years?
That is Court Fees Act is absent about it. It says only
For specific relief, what is the normal standard?
I'll come to it, sir. So section 26 says you only pay a court fee of 15 rupees under section 43 of the Court Fees Act.
For example, that is 2015 it is modified. Today we are in 2024. So every year we need to pay.
That your Court Fees Act is silent about it. It only says 15 rupees.
Okay.
Take advantage of that.
Okay.
Add an extra court fee to your fees which you are to receive. But here in a rectification suit, what you are supposed to file is, you have to file the parent document, and the plaintiff itself, you must make it very, very clear what are the discrepancies which arise in the parent document, what are the corrections you want to make in the subsequent document. Then you also make the registrar or the MRO as a party, because the concerned entity's corrections has to be made only by that particular authority, and also make a prayer that a copy of the decree may be sent to the MRO or the sub-registrar to make the necessary corrections in their records.
If we may not party MRO,
Dispense will be the 82.
if we may not party MRO or
If you
Tahsildar,
don't make a party, I did that mistake in my profession, sir. The question is, registrar will say, where is the copy of the decree? Court should send the decree to me, not you. So, make a pro forma party. But you say, pray, make a prayer. Copy of the decree may be sent to the registrar or to the MRO to make the necessary corrections. Right? Then, that is what section 26 is, a very, very small section. Then we go to the section 27, 28, 29 of the specific relief, which speaks about rescission of contract, or what is called RESCISSION, rescission of contract. That means avoidance of a contract. Avoidance of a contract, retracting from a contract, or taken by the contract not to be implemented is what is called rescission of the contract. The word rescission comes from the word resigned. Resigned means avoid, retract, revoke, cancel. That is called rescission. Here, when a contract is void or voidable for any reason, then in that case, you can ask for the contract to be rescinded. For example, most of you know, when you make out an agreement, the balance of the sale consideration has to be paid within 45 days or within 30 days, let us say. Or let us say, or even after 1 year or 2 years, the money is not paid. You can give a notice of revocation and say, since you have not followed the terms of the contract, you have not paid the balance of the sale consideration within the time granted under the agreement of sale, I resign from the contract and I'm cancelling that contract and I don't want to perform my obligations under the contract. Then in that particular case, the contract gets resigned. But please remember one thing, that most of you write a sentence there. In case the balance of the sale consideration is not paid, the contract can be rescinded. The advance and earnest money shall stand forfeited. But please remember, you cannot avoid the contract at one stage and then keep back the money what you have received and say that I'm not going to return it. The court will order you, when in case you want to resign the contract, return back that money what you have taken. That is what is called, that is called the doctrine of unjust enrichment. You cannot enrich yourself, you cannot make yourself rich at the expense of the other. If you want to avoid the contract on the ground of voidability or voidness, then in that case, whatever benefits are had and received under the contract has to be restored back to the opposite side based on the principle of what is called restitution or principle of unjust enrichment. Right? Then we go to see, now if you, a particular practical anecdote as far as specific performance is concerned is, suppose let us say, I think most of you know what is the definition of the word agent. What is meant by contract of agency? An agent is a person who acts as a convey pipe, brings about a contractual relationship between his principal and a third party. He acts like the connecting link or the coupling between the principal and the third party, and then he is the intermediary who brings about the contract. Then let us say he assures the performance of the contract on either side, and then he acts as the agent. Then whatever monies have to be paid by the buyer, he pays the money, or he says he undertakes to pay that money, executes promissory notes also for that. Now, how you file a suit for specific the document is normally the agreement of sale, or sale deed is executed, let us say, on the promise saying that the money will be paid by the other side, that the promise by the purchaser or his agent on behalf of the purchaser. Then let us say there is a breach of the obligation. The sale deed is executed, but the money is not paid. Then in that particular case, under the law of agency, since the agent has acted as the intermediary between the principal and the third party, then the question is, under the law of agency, the agent is liable to pay that money which is remains unpaid towards the unpaid sale consideration. There cannot be a decree for specific performance, but one thing is that money had and received or promised to be paid, which is not paid, for which the broker, or I don't say broker, real estate agent acts as the intermediary, acts as the agent, is bound to make that payment to the vendor concerned. That is how, and that is the reason when you draft a plate, you will have to be very, very careful to say that the agent as well as the principal are jointly and severally liable to return the money. And because the agent has given you the checks given by the principal, is bound, the checks have gone normally. And based on that, you can always say, I am entitled for return of the money, those specific performance cannot be granted. Then we go to cancellation of instruments. And then, before that, you must know what is meant by a void document and a voidable document. In this regard, void means right from the beginning itself, it's unenforceable under the law. There is no two opinions about it. As far as voidability is concerned, again you have to revert back to the Contracts Act. Section 15 to 22 of the Contracts Act deals with the vitiating elements of contract. One is called coercion, section 15. Then you have got undue influence, then you got misrepresentation, then you got fraud, then you got mistake, unilateral and bilateral. First, coercion means where section 15 or 16 of the Contracts Act says where you put the person under threat of injury or bodily harm, loss to his person as well as to the property, and obtain his consent, that consent is not free. Then, in that case, the party so affected can always take up the plea of coercion and say that I want to avoid the contract, ask the other person to return all the documents that have been taken. That is called coercion. And a భయపడి చేసి తీసుకోవడం అన్నమాట. Then you have got what is called undue influence. Undue influence is where one person is in a dominating position compared to the other, uses his position to his benefit and to the detriment of the other, and the other person to whom such confidence is given acts on the representation made by his superior and does something which would not have done under normal circumstances, it is said to be a contract vitiated by undue influence. Or I use a single word saying that where one person is in a fiduciary capacity compared to the other, use and the other person acts on your fiduciary capacity, changes his position, which you would not have done but for your representation, then in that case, the contract is said to be voidable. There is no free consent and it can be avoided. The leading case of that aspect is the case of Alcard versus Skinner, ALLCARD versus Skinner, SKINNER. I'm coming to something. Yes, let us come to the theoretical part of it. 1 minute, please. Say, Alcard versus Skinner is most of us are God-fearing and more particularly Christians. They believe the church more than their husbands. Of course, no Christians are sorry if I made any aspersions. Here, question is: suppose you want to do, in every family in Kerala and other places, one female member of that house joins the church. It is a principle which is followed, and Kerala girls especially make very good nurses also, and they are also in the what is called the church. They serve the Lord. Here the question is, Alcard was a maiden rather unmarried girl like all, like of course I don't say anyone, everyone. So it's like some of you. Then she got fed up with Jagame Maya, Lokame Maya, and she went to the mother superior and said, "Sir, I wanted to join the church as a nurse, I want to join the church." No. Then the mother superior said, "If you want to join the church, Anni Tyagam Jayala. You dedicate all your properties to the church, we'll take care of you and don't bother about it." Then this girl was exuberant that she's going to serve the church. Then she remained in the church for 5 years, and then after that, she developed a dislike to the sisterhood and she wanted to come out. Literally, she left the church and came out. And after 2 years after coming out of the sisterhood, she brought an action against the mother superior, saying that the mother superior was in a fiduciary capacity compared to her, and she brainwashed her completely. She dedicated all the properties to the sisterhood. She wants to get back all the properties. But in this case, the court agreed with her, saying that the mother superior was in a fiduciary capacity. But she waited for 3 long years before bringing an action against the mother superior. They say that since you have come delayed and you had independent legal advice outside, you cannot take back your properties which you have dedicated to the church. That was held in, though undue influence was there, she was not allowed to take back the property. That was the case of Alcard versus Skinner. Then we go to misrepresentation. Misrepresentations, most of us as advocates specialize in this. Suppose let us say senior is very much in the court. In some other court, let us say, "Sir, my senior is seriously ill, sir. He is in the ICU. Then please give me an adjournment." Then the judge sympathetically says, "Oh, no, take." Or you say, "Sir, you may post it tomorrow or day after." You know that judge is not going to post it tomorrow or day after. She'll post it after 10 days or 15 days. Then your senior comes and argues the matter. Here you make a representation without knowing the truth or without verifying the truth or otherwise, it is called misrepresentation. Without any malice in your mind, you make a representation which is false. Second thing is, you do not know anything about it, but you still make a representation that is called misrepresentation. But fraud is a dangerous species. It's a species of misrepresentation. where you know that what representation you are making is false, but still you make that representation. Or second thing is you make that representation in order to defraud or deceive the other person. That is what is called fraud. You would understand this. So here, as far as Limitation Act is concerned, as far as fraud is concerned, there is no limitation at all. From the date when the fraud is discovered, the limitation period starts. Then you got what is called the last aspect called mistake, unilateral and bilateral. Bilateral means where the party, let us say, no property exists, but still a document is executed. Then both the parties do not know where the property is. Idea of the property is not known. Then in that particular case, it's a bilateral mistake committed by both the sides. The contract is voidable. It need not be performed at all. That is one of the ingredients. Unilateral mistake. Unilateral mistake is నాకు 10 ఎకరం అమ్ముతాను అనుకున్నాను వాడు నాకు 5 ఎకరం అమ్ముతా అంటాడు నేను 10 ఎకరం నాకు కావాలి that is mistake committed by you not by the other side you cannot avoid the contract so these are called basically what is called vitiating elements of contract where consent is not free. So when consent is not free, it gives rise to a proposition to say it's voidable. Voidable is it can be avoided at the option of the party whose consent is not free. So now we come to the section 31 to 33. Cancellation of instruments and decrees. Suppose let us say the instrument is taken by fraud or is taken by misrepresentation, it is taken by coercion or it is taken by undue influence or mistake unilateral or bilateral. Then in that particular or a decree has been passed where you are not made a party to it, though you are a proper and necessary party, you can challenge that by saying, sir, let it be cancelled. Or the agreement has been obtained from you under threat of injury or whatever it is. Then in that case, you can always file a suit for cancellation of that particular instrument to declare it as null and void. Then decrease, that is decrease also. Then instrument, suppose the instrument fails for various reasons, you can challenge that instrument and get it cancelled by due process of law. That is what is called cancellation of instruments as laid down in section 31 to 33. One basic thing you must remember is 31 to 33, you can lay a suit only when you are a party to that agreement, only when you are a party to the proceeding. Unless you are a party, you cannot file a suit for cancellation. Then you come to the declaration part of it, 34 and 35. Where? 34. No, we come to. Yes, I'll come to one. Suppose let us say it's a dispute between the brothers rather, put it that way. Both of them are, I think, Telugu house law that they do this goldsmith business. Both of them are running it
This
together.
is a live case. This is a live case. What is trying to say? Please listen to it. What is your next intention? Because we have done the case, it's still happening. Let us see what is that you are going to give the input. How do you deal this case in your prospects? Please give your version so that what we have done you will able to understand. This is not an experiment what we have done. It's an actually happening case.
Okay. In a particular case, what happened was both the brothers were jointly sitting in a shop and doing this goldsmith business. Then their bucks were coming and they were distributing the money among themselves. Then subsequently, it so happened that the younger brother lost his eyes; he could not work. Then the elder brother was doing the business. Then the question is, there were some disputes and differences between them. Subsequently, they called a meeting of the so-called panchas who were there.
Panchanama.
Panchanama was done.
Panchayati,
And
in fact, Panchayati.
Panchayati was done, and they took an undertaking that the elder brother will pay 16 lakh of rupees, which was found due and payable to the younger brother, and he said he will pay the money, and he signed and the presence of witnesses. And there, the person who scribed the document was the son of the elder brother.
Scribed.
And he was only asked to note, it was dictated by one of the elderly members. And according to this dictation, it was written in Telugu. The question is whether the 16 lakhs is due and payable is a question which has to be decided. In that particular case, though by mistake, that document was marked. Subsequently, I filed a petition under Order 13 Rule 3 to demark that document. The judge, in the course of the judgment, dismissed my petition but said no money was paid, no money was transferred, there is no consideration at all. Now, how you decide? So the question is, once you come to a particular figure of 16 lakhs, it should be supported by your documents, supported by account books, supported by vouchers, supported by the liability, so on and so forth. They are not there. The question of liability of the defendant does not arise. That is the plea taken. How far this plea is tenable?
ఇప్పుడు చెప్పిన కేసు ఏదైతే మాట్లాడుతున్నారో మీరైతే ఏం చేస్తారు ఆ పర్టికులర్ కేసు ఎనీబడి కెన్ పార్టిసిపేట్ ఇన్ దిస్ పర్టికులర్ కేసు ఐ వెల్కమ్ ఇట్ బికాస్ ఇట్ ఈస్ ఆల్రెడీ హ్యాపెనింగ్ ఇన్ ద కోర్ట్స్ స్టిల్ హ్యాపెనింగ్ ఇట్ ఈస్ ఇన్ అవర్ ఆఫీస్ ప్లీజ్ యూ కెన్ గో హెడ్ చెప్పండి సార్
So, what is the business happened previous years? What are the income tax filed? And what is the profit? They should maintain some books, right? So we'll take that books based on that. So what is the previous year? Based on that, so what is the share of this day? And what is the present year expenditure? So we are considered.
Both of them are not income tax assessors. Both of them do not maintain account books.
Yes,
There is no.
I
And for different.
we are for defendants sir.
we have given that agreement.
Elder brother.
See, I will be very clear. Actually, the case is the documents which are there, which has been written. ఒక అండర్టేకింగ్ లెటర్ ఇచ్చారు మనం సేయింగ్ దట్ ఏదైతే అప్పు తీసుకున్నారో ఆ 16 లక్షలు కట్టాల్సిందే మీరు అని చెప్పి వాళ్ళ కొడుకు చేత రాయించారు. ఇట్ వాజ్ రిటన్ బై హిస్ సన్. ఈజ్ అబౌట్ 23. Okay, and then it is scribed. It is not by his mind. He has not written. The elderly person is sitting beside him. In the video, it is very clear. They have produced a video evidence, but still, that gentleman is dictating. This fellow is writing, and it was signed, duly signed before everybody. Now, question comes here: what is next? అవును. ఇచ్చాడు కొంతకాలం ఇది ఇస్తూనే ఉన్నాడు. ఎప్పుడు బిజినెస్ మొదలు పెట్టినా అప్పటి నుంచి మొదలుపెట్టి చేస్తూనే ఉన్నాడు. ఈజ్ గివింగ్ షేర్, బట్ ఏంటంటే ఈజ్ గ్రీడీ అబౌట్ అమౌంట్ అండ్ ఈజ్ గివింగ్ ఎ లిటిగేషన్ సే దట్ దిస్ ఫెలో ఇస్ ఎట్ అవే ఎంటైర్ అమౌంట్ అని చెప్పి ఒక ఇప్పుడు మీరున్నారు సార్, మీరు మీ బ్రదర్ చేస్తుంటే మీ బ్రదర్కి మీరు ఇచ్చారు. ఇచ్చిన తర్వాత నెక్స్ట్ మూమెంట్ ఏం జరిగిందంటే వాడు ఎందుకు తినాలి, ఇది నాది కదా అని ఒక గ్రీడ్ స్టార్ట్ అయింది. ఈ స్టార్టెడ్ రైటింగ్ ఆల్ ద థింగ్స్ ఆడ అకౌంట్స్ ఏం లేవు. దిర్ ఇస్ నో అకౌంట్స్ ఫర్ ద పర్టికులర్ హాస్పిటల్స్ అండ్ ఈ స్టార్టెడ్ డిమాండింగ్ అబౌట్ 16 lakh rupees till now your work. బ్రదర్ తమ్ముడు ఇది ఇన్ బిట్వీనే జరిగింది. వాడికి ఇవ్వాల్సిన ఇచ్చిన అమౌంట్ తర్వాత కూడా ఈజ్ గ్రీడీ అబౌట్ ద అమౌంట్.
What basis
There is
they
no basis.
decided
There
this
is
16
no
lakhs?
basis. There is no account books. Open the patram and raskunaru.
That is what it is.
And open the patram cannot be an agreement. Open the patram and understanding. But the question is, it should be supported by documents, isn't it, sir? What my friend said was account books, vouchers. Then he suspended his business. That is the younger brother did not come to the shop for 8 years.
They'll
Where
come
is
to
the
you,
question of his participating in the business?
There is no accounts work for the elder brother who is blind enough. He has just done on the basic C. There is a relation between brothers. So on a trust basis, he has done the business. And again, to feed his family, he has given amount also. Now, can you tell me how this particular evidence which is submitted in the court of law, is it valid or not? The video, the total video, I have the video, I can show it right away. అవును.
సో ఇండిపెండెంట్ గా వాళ్ళు రాస్తున్నారు కాదు. సో పంచాయతీ వాళ్ళు డిసైడ్ చేశారంటే దే మైట్ బి కాన్ టు ఆల్ ది ప్రాసెస్ కాన్ఫిడెంట్ వితౌట్ నాలెడ్జ్ జస్టింగ్ అవుట్
రాశారు అట్లా అకౌంట్ బుక్స్ వెరిఫై చేసి రాశారని రాయలేదు దాన్ని.
అకౌంట్స్ వెరిఫై చేయకపోయినా ఇప్పుడు వాళ్ళు ఎవరైతే ఉన్నారో వాళ్ళు బ్లైండ్ గా అయితే జస్టిస్ చేయలేదు.
Sir,
అందరూ
I'll show
ఉన్నారు
you.
కదా.
Sir, I'll show you something here. Then you can understand why because why are we are looking into
and
that.
the judge himself has written, there is no passing of consideration, there is no giving of money taking of money, the question of liability is not proved or established through that undertaking or open the patram as you call it.
MOU. Open the patra is nothing but MOU.
Yes, that is one. But here again, వాళ్ళంతా వాడుతున్నట్లు ఇతను వచ్చేసి అప్పుడు వాళ్ళ బ్రదర్ వచ్చి అది బిజినెస్ వచ్చేసి ఇల్లు అన్డివైడెడ్ ఫ్యామిలీ
లేదు సపరేట్ ఉన్నది.
ఓరల్ అగ్రిమెంట్ ఆల్సో ఎన్ఫోర్స్.
వాళ్ళు ఓరల్ అగ్రిమెంట్ ట్రీట్ చేయాలి.
సార్ అది బాల్మర్ వర్సెస్ బాల్మర్ కేసు లాగే ఉంది సార్ ఇది కూడా.
That is what.
ఓరల్ అగ్రిమెంట్ క్రియేట్ చేసి
And judge has given a categorical finding. There was no passing of consideration. There is no payment of money, admission of liability, nor the person defendant has received the money which he has not paid. The question is, once the consideration is not there, the contract itself is open the bottle goes.
The particular case is running from 2017.
అదే సార్, if it is given, there is legal consideration, legal obligation లేదు కనుక దానికి it is love and affection తోటి అతను ఇస్తా అన్నాడు.
అంతే.
Whatever it is through love and affection.
వాడిని కంపెల్ చేసి రాపిచ్చారండి.
ఇప్పుడు కంపెనీలో కొహెర్షన్ లో ఉంది.
వాయిడబుల్ అవుతుంది అది.
ఆ ఎవిడెన్స్ పెడితే వాళ్ళు ఏమంటున్నారంటే నవ్వుతున్నారు చేశారు.
ఇన్ఫ్లుయెన్స్ అండి, అన్డ్యూ ఇన్ఫ్లుయెన్స్ అండి.
అక్కడ
ఎమోషనల్ గా ఇన్ఫ్లుయెన్స్ చేయొచ్చు.
ఫేషియల్ ఎక్స్ప్రెషన్ చూస్తారు సార్.
ఇన్ఫ్లుయెన్స్ వేరే సార్, ఇన్ఫ్లుయెన్స్ వేరే.
ఫేషియల్ ఎక్స్ప్రెషన్
నాకు
చూస్తారు వీడియోలో.
The question of his getting his share does not arise. Nor there is any open between them that so much amount will be paid towards his share. It is according to the piecework which I receive, according to that we share. అది ఎక్కడ ఎస్టాబ్లిష్ చేయలేదు.
I have an చెప్పండి.
లేదండి ఇది
గోల్డ్ స్మిత్ ఎలా రన్ చేస్తారు సార్? సార్ గోల్డ్ స్మిత్ ఏం చేస్తారు? They just open a workshop and do it. They will not have any kind of what do you call it? కంసాలి పని ఏం చేస్తారో అదే చేస్తారు తప్ప దాన్ని తీసుకెళ్లి ఎగ్జిబిట్ చేసి సేల్ లో ఉండవు. What they have done is that.
Doing business together for long time.
Brothers, sir. Brothers. ఇద్దరు brothers, own brothers.
Long term business చేస్తున్నారు కాబట్టి కస్టమర్ బేస్ కానీ అదంతా చేస్తున్నారు కాబట్టి
That's the problem here. That's the problem here. అసలు ఏది లేదు అక్కడ. That is what the accounts books are not managed, not even returns. Anything are not maintained properly by them. Anything, nothing. See,
then that evidence can be produced in court with electronic evidence 65 people submit చేస్తారు. How far that is admissible?
that is the question here.
Admissible ఆ కాదా?
That is the challenge right now going in the court right now.
What law says about that?
The entire video is about 28 members.
No. What law says about that particular written agreement?
they say there is no passing of consideration.
How can they say, sir? It is written one by one overlap అవుతున్నది. It is given in hand.
How can you say anything? That is a finding of the court that has not been challenged.
వాళ్ళు ఎవిడెన్స్ లీడ్ చేశారా?
Yes, sir. They didn't talk about anything. Now the order passed by the court.
That is it.
అంటే ప్లీ తీసుకుంటేనే కోర్టు, అంటే మనం అడిగితేనే.
Pardon, sir? Sir, what 7 years నుంచి వాడు సాఫ్ట్వేర్ రావట్లేదు.
See, custom ఇది you are doing your business, profit ఈజీగా ఇస్తారా? I am asking the same question, my dear. You are doing the whole total job, whatever job you are doing, and will you pay the amount to him? Are you you have such a golden heart? He says that I am coming. In the petition, what he says I am coming.
No,
I am coming
he has
regularly.
not said so. He has said he has suspended his business for the past 10 years. He has not been coming to the shop. There is a
But
clear
still he is
cut-
claiming the amount.
And another thing that even that amount what was due.
అది మామూలుగా పోయేది సార్. ఆయన ఏంటంటే ఈ గోల్డ్ స్మిత్స్ జనరల్ పనిచేసింది అన్న చార్కోల్ ఆ టైంలోనే పోయేది. అది వర్క్ చేస్తుంటే రాను టీవీ
ఇంట్లో కూడా ఏ పీరియడ్ నుంచి ఏ పీరియడ్ వరకు నా వాటర్ రావాలని రాయలేదు. సరే,
ఇదొక పర్టికులర్ కేసు.
ఇంకో అద్భుతమైన కేసు
One
ఒకటి
by
సార్,
one,
ఒక
let us-
నిమిషం.
let- let-
అవునండి, ఉండండి సార్. అనిల్ గారి కేసు ఒకటి మా మేడం గారే చెప్పాలి.
మనకు లేట్ అయిపోతుంది. వేరే చాలా ఉంది కదా.
స్పెసిఫిక్ రిలీఫ్ యాక్ట్ లోనే అంటే మేము ఫేస్ చేసిన ఒక పెద్ద స్కామ్ బయటపడింది. సో సార్ కూడా మేము చెప్పి
After
ఎక్స్ప్లెయిన్
this, we'll
చేసాం.
finish it and come, sir. Then one more subject remains.
See, as far as the ground of limitation is concerned, in a suit for specific performance, it is governed by Article 54 of the Limitation Act. It says if the date is fixed for performance, it is 3 years from the date fixed for performance. But if no date is fixed, it is to be exercised at any time. The question is the period of limitation doesn't arise. So to save limitation, what we advocates do is, before the time comes to an end, we give a notice to the opposite side, I'm ready and willing, come and register the document. Suppose he refuses that notice, from that time I get a period of 3 years. That is Article 54 proviso. Then as far as cancellation is concerned, it is 3 years. 3 years from the date of the document, that is Article 58 and 59 of the Limitation Act. Then we come to the next aspect called declaration. Declaration is mostly an innocuous remedy which is not executable under Order 21 Civil Procedure Code. Declaration arises when a status, position, character, or pedigree is claimed by one person and it is denied by the other side. Then you can get your status declared, position declared by a decree or declaration that you are entitled for it. This arises mostly in the case of family courts. South Gola. Suppose the deceased dies, both of them say that I am the legally wedded wife, the other person says I am the legally wedded wife. The question is who should decide who is the legally wedded wife? It is then they file a suit to declare for that promotion and all. Then pay your character, that is in whatever character I told you as a wife or whatever it is. Then the legitimacy or illegitimacy of the children also you can get it declared to a court of law. Though you, and suppose I take a concrete example, you file a suit for perpetual injunction, let us say, you obtain an injunction, but the other side still, in spite of the injunction order, constructs the property where he has been restrained from doing it. No doubt. The question is, if you allow the suit to remain, tomorrow you will only get a decree for a specific perpetual injunction. You will have to only frame the decree and then exhibit it. But if you want a concrete remedy, then what you have to do is you have to amend your plea and ask for the additional remedy of mandatory injunction to remove the offending structures and put it back in the same position which it was prior to the illegal act being committed. Of course, you can say, sir, you got one more provision under Order 39 to 2A, disobedience and violation of the injunction orders. But that will not give you a final relief. The question is you must amend your plea so that your plea remains alive. So here the question is declaration arises under various circumstances. Right of easement, let us say. Suppose let us say right of way, right of passage, right of ingress, right of egress, right of worship, right of using the bund for coming to your field, right for irrigation water, that you don't have a right over your neighbor's property, but by long usage for 20 long years, you have acquired a right which is by prescription. By 20 long years, you are enjoying that right. That right cannot be disrupted. You can always ask for enforcement of that right by filing a suit for enforcement of that right. Right? You can, or let us say, mandatory injunction also you can ask. But the question is, please remember, most of us commit that mistake. Allow the perpetual injunction to remain. You are only the question is, if you want a concrete relief, you must ask for a declaration and also for mandatory, what you call mandatory injunction also to remove the structure. Then there is one more provision, section 34(1) of the Specific Relief Act, which says when you ask for declaration of title, you must also ask for possession. If you don't ask for possession, your suit can be dismissed. Are you able to understand this? So the question is, all reliefs which might or ought to have been taken will have to be taken. If not taken, is deemed to be waived. And in Order 602 CPC, it is said, or what is called plead and then prove, not prove and then plead. Are you able to understand this? Then you have got interpleader suits that you need not bother about. Very rarely such type of suits are filed. Then important section is what is called section 37, 38, 39. It speaks about law of injunctions.
please remember the spelling of injunctions is INJUNCTION, not INGEJECTION. His landlord is a doctor. He knows only injunction, does not know what injunction is. An advocate knows only injunction. He does not know what is injunction. So the question is, when a party comes to, I think most of you belong to the districts, no, a party, sir, stay order kitchen, sir, stay order kitchen. Sir, stay order తీసుకుంటే తక్కువ ఉంటుందా సార్ ఇంజంక్షన్ తీసుకుంటే ఎక్కువ ఉంటుందా బాబు స్టే ఆర్డర్ కాదు యూ ఆర్ అన్ అడ్వకేట్ సార్ డోంట్ సే స్టే ఆర్డర్ యూ సే దట్ ఇట్స్ అన్ ఇంజంక్షన్ ఆర్డర్ సో ద క్వశ్చన్ ఇస్ ఇంజంక్షన్స్ is laid down from section 37 to 39 of the specifically defined. There are three types of injunctions. One is called interim injunction, another is called temporary injunction, another is called perpetual injunction, and another is called mandatory injunction. As far as interim injunction is concerned, interim is it's something like crocin. When you get fever, crocin vescuta about the dolo, or dola, whatever it is, you consume. Not that your fever is going to go, at least ఉపశమనం అని జరుగుతుంది. తలనొప్పి వచ్చిందంటే మీరు అమృతాంజన్ కానీ జిందు బాంబ్ కానీ ఏ బాంబ్ కానీ వేస్తారు. శాస్త్రీ బాంబ్ ఒకటి కొత్తగా వచ్చింది. సో యూ అప్లై దట్. ఏదో మంట పడతారు ఏదో అవుతుందిరా బాబు అని ఏం పోయి అది ఉంటేనే ఉంటుంది కానీ ఫర్ ద టెంపరరీ పీరియడ్ యూ గెట్ దట్ రిలీఫ్. సో ఇంటర్మీడియట్ ఫేజ్ you ask for a temporary injunction, court grants you an interim injunction on certain terms and conditions. It remains in force not permanently for a limited duration of time. And please remember, once the other side appears, files a counter, files the documents, you are heard threadbare, you are heard and the other side also is heard, and the court passes an order accordingly. Suppose you make out a case, then your petition is allowed, your injunction is granted. The interim injunction gets converted into temporary injunction. What are the three basic principles which are to be followed, sir? One is prima facie case. Prima facie case is on the face of it, you have got a triable case on facts as well as the documents. Then balance of convenience. Me pakka nyayam undi, other side pakka nyayam ledu, you establish by facts and documents. Then relative hardship. Suppose injunction evavapothe, what is the damage which is caused to you? What is the injury that is likely to be caused to you? That you have to prove and establish before the court of law. These three basic principles have to be followed as far as injunction is concerned. And please remember, injunction is supposed to be a discretionary remedy. Just because you come to the court doesn't mean that the court has to grant an injunction. Then what happens is the court has to be satisfied because this position has arisen because of the amendment of Civil Procedure Code by Act 46 of 1976. In 1976, what the CPC said was, they said immediately when an injunction suit is filed, don't grant absentia injunction unless the other side is heard. That is what is called adi alteram partem. Don't condemn another person without his being heard. So the question is, of course, please pardon me for using that word. Justice Subhash Reddy used to openly say, ఏంటా బాబు స్టేటస్ కో ఆర్డర్ ఇస్తారు కోర్టులో ఈ కొజ్జా ఆర్డర్ మొగది కాదు ఆడది కాదు ఏదో స్టేటస్ కో ఇస్ ఇంటర్ప్రిటెడ్ ఇన్ ఎ డిఫరెంట్ వే అకార్డింగ్ టు స్టేటస్ కో మీన్స్ సంథింగ్ ఎల్స్ అకార్డింగ్ టు మీ స్టేటస్ కో మీన్స్ సంథింగ్ ఎల్స్ స్టేటస్ కో ఆర్డర్ తీసుకుంటే దాని మీద కట్టేస్తారు కూడా సో ద క్వశ్చన్ ఇస్ ఐదర్ యూ అలౌ ఎన్ ఇంజంక్షన్ అప్లికేషన్ ఆర్ డోంట్ అలౌ ఎన్ ఇంజంక్షన్ అప్లికేషన్ సో వితౌట్ హియరింగ్ ది అదర్ సైడ్ ద కోర్ట్ కెనాట్ పాస్ ఎన్ ex parte injunction order and it says it can pass ex parte orders provided it gives reasons for it why injunction can be granted. But please remember, we don't have vice status. ఎందుకురా బాబు ఏదో స్టేటస్ స్టేటస్ కో ఇవ్వండి స్టేటస్ కో ఇంటికి తెలియదు వాడికి తెలియదు స్టేటస్ కో ఆర్డర్ ఇస్తారు స్టేటస్ కో till now I am not finding the legal history also what do you mean by status quo. In labor law language it's called doctrine of laissez-faire. Things stand where they are. అంటే ఇక్కడ నిలబడి అక్కడే నిలబడాలి అక్కడి నుంచి జరగకూడదు వాడు అక్కడ నిలబడి అక్కడి నుంచి జరగకూడదు. The question is, status quo orders gives rise to wide interpretations. The question is either the court should grant injunction or not to grant an injunction. But please remember, no court does it because why should I use my brain? Why should I give reasons? Why should I read the law? Why should I read the facts? Of course, that's the negative attitude of judges now, unfortunately. Those days before the amendment, straight away injunction orders used to be ordered, but now not so, unless the other side is heard. So other side has to be heard before an injunction order is passed, and that is the reason they pass status quo orders. And one important thing is, one who comes to equity must come with clean hands. You must not suppress. Client give me 5 minutes.
You take break.
ఒక్క కేసు డిస్కస్ చేస్తాం, మీ ఒపీనియన్ కూడా చెప్పాలి, ఎందుకంటే ఇది ఒక స్కామ్. ముందే చెప్తున్నాను, ఇది ఒక స్కామ్. విల్ యూ టేక్ దట్ ఆర్ నాట్? ఛాన్స్ మీరే చెప్పాలి. There's a client approach to us. He's a professional guy, మెడికల్ ఫీల్డ్ లో ఉన్నాడు. సేయింగ్ దట్ నేను బ్యాంక్ దగ్గర అప్పు తీసుకున్నాను, బై కొలెటరల్ గా నేను 2 ప్రాపర్టీస్ నేను ప్లెజ్ చేశాను లోకల్ గా హైదరాబాద్ లో. నాకు డబ్బులు కట్టడానికి 1 shot లో నేను కట్టడానికి రెడీ. ఓకే, ఈ గోట్ ఆల్ ది డాక్యుమెంట్స్ వాట్ ఎవర్ ఇట్ ఈస్ నెసెసరీ. ఇతను వచ్చేసి ప్రొఫెషనల్ ఇన్ మెడికల్ ఫీల్డ్. ఈయన ఏం చేశాడంటే నా పేరు ఎందుకులేండి. సో ఆయన ఏం చేశాడంటే ఇద్దరు లేడీస్ పేరు మీద దట్టు ఈజ్ ఓన్ ఎంప్లాయీస్ మీద పెట్టాడు, ప్రమోటర్స్ కింద పెట్టి వాళ్ళని. మరి ఏం చేశాడో ఏమో తెలియదు, మాత్రం బ్యాంక్ మాత్రం 4 కోట్లు ఇచ్చేసారు, 4 crores ఇచ్చింది. నా దగ్గరికి వచ్చి 2 ప్రాపర్టీస్ నావే, 2 లేడీస్ అబ్స్కాండింగ్. 2 ప్రాపర్టీస్ నావి, నా ప్రాపర్టీస్ కావాలి. ప్రాపర్టీ వాల్యూ ఇస్ మోర్ దెన్ ఎర్లియర్. డబ్బు ఇచ్చింది బ్యాంక్ టువర్డ్స్ ఫర్మ్స్. కంపెనీ తీసుకుంది. కానీ ఇది బ్యాక్ ఎండ్ లో ఏంటంటే ఈయన ప్రమోటర్ కాదు, ఈయన అందులో ఒక పొజిషన్ తీసుకున్నాడు. కాకపోతే మొత్తం కంపెనీ అంతా ఇంతే, ఓన్లీ బినామీ కింద వాళ్ళిద్దరిని కూర్చోబెట్టాడు. దే ఆర్ జస్ట్ సైనింగ్ అథారిటీ. ఈ క్లయింట్ మీ దగ్గరికి వచ్చాడు, ప్లీజ్ లెట్ మీ నో మీరు ఏం చేయదలుచుకుంటారో చెప్పండి. అంటే మేము ఎంత దూరం వెళితే మా ఫ్యూజులు అవుట్. బేసిక్గా మేము అక్కడికి వెళ్ళిన తర్వాత మేము వీ మైట్ బి A4 or A3, సీరియస్గా అడ్వకేట్ A3 A4 నుంచో పెడతారేమో అనుకున్నాం. అక్కడికి వెళ్ళిన తర్వాత మా ఫ్యూజులు అవుట్ మేము స్టేజ్కి ఉన్నాం. అందుకని నేనేం అడుగుతున్నాను, మీరైతే ఏం చేస్తారు ఈ పర్టికులర్ కేసు? హౌ డూ టేక్ దిస్ కేసు? ఏం లేదు.
ఇది సీనియారిటీ సార్, ఇది సీనియారిటీ సార్, ఇది సార్ సీనియారిటీ. దిస్ ఇస్ వాట్ సీనియారిటీ. బొమ్మ ఇది సీనియారిటీ. దిస్ ఇస్ వాట్ ఇట్ ఈస్.
సార్ వసంత్ గారు, యు ఆర్
ఫ్యాబ్రికేటెడ్ డాక్యుమెంట్స్.
కంప్లీట్ ఫ్యాబ్రికేటెడ్ డాక్యుమెంట్.
ఎందుకంటే డబ్బులు ఇస్తే వాళ్ళు మేనేజ్ అయిపోతారుగా. బ్యాంక్ లో మీరే ఎంప్లాయ్ అనుకోండి, మీకు కోసం డబ్బులు ఇస్తే మీరు అన్ని ఓకే ఇస్తారు కదా.
గ్రౌండ్ లెవెల్లో ఎటువంటివి జరిగిన అండ్ somehow they manage the bank.
అదే అనేది, మీరు బ్యాంక్ ఎంప్లాయ్ అయితే మిమ్మల్ని మేనేజ్ చేస్తే సరిపోతుంది కదా అన్నిటికీ. అయిపోయాయి 4 కోట్ల దగ్గర 10 లక్షలు చెయ్యరా?
ఏం సార్,
బ్యాంక్ వాళ్ళని మేనేజ్ చేస్తే, డబ్బులు ఇచ్చి మేనేజ్ చేస్తే ఎన్ని ఫ్యాబ్రికేట్ గా అవుతారు?
ఫ్యాబ్రికేట్ అవ్వలేదు ఇక్కడ. ఫ్యాబ్రికేట్ అయింది డాక్యుమెంట్. ల్యాండ్ ఉంది సార్ వసంత్ గారు, ల్యాండ్ ఎగ్జిస్టింగ్.
అంటే మేము ఇన్వెస్టిగేషన్ మాకు ఎక్కడ వచ్చింది అన్నది మేము చేసింది మేము చెప్తాం. మాకు ఎక్కడ డౌట్ వచ్చిందో చెప్తాను. అంటే మేము ఇన్వెస్టిగేషన్ అంతటి ఇరుక్కోకుండా మేము బయటకు వచ్చాం ఈజీగా. మా ఫ్యూజ్ అవుట్ యూ విల్ ఎక్స్ప్లెయిన్. మేము గ్రౌండ్ వర్క్ చేసిన తర్వాత దండం పెట్టాను.
ఒక పెద్ద ఫర్మ్ మాకు రిఫర్ చేసింది కేసు. వేరేంది నా ఫర్మ్ లోనే 18 members ఉన్నారు అడ్వకేట్స్. ఆల్ ఆర్ సిండికేట్స్. ఒకటే టైప్ ఆఫ్ కేసెస్ చేస్తారు. దే ఆర్ ప్రొఫెషనల్స్ ఇన్ బ్యాంకింగ్ ఓన్లీ. అలాంటి వాళ్ళ నుంచి మాకు ఈ కేసు వచ్చింది అని అంటే ఎక్కడో చిన్న డౌట్. వెళ్ళాం, క్రిమినల్ కేసు కూడా ఉంది నా మీద. నాకు ఇక్కడ ప్రూవ్ అయితే చాలు, ఈ ప్రాపర్టీస్ నావి అని ప్రూవ్ అయితే చాలు. ఐఎమ్ రెడీ టు షెల్ డౌన్ ఆల్ అమౌంట్ ఇన్ వన్ షాట్. ఇది చూపించుకొని నేను నా క్రిమినల్ కేసుని ఎక్కడ ఉందండి, CCS పోలీస్ స్టేషన్లో ఉంది క్రిమినల్ కేసు, నేను దాన్ని విడిపించుకోవాలి అని చెప్పారనమాట. ఒక్క డాక్యుమెంట్ లేదు, నాట్ ఈవెన్ సింగిల్ డాక్యుమెంట్. ఆయన చూపించింది ఏంటంటే పలానా ఫార్మా కంపెనీస్ నావి, ఈ అగ్రిమెంట్ ఆఫ్ సేల్ నేను ఆ లేడీస్తో చేసుకున్నా. వాళ్ళు మోసం చేసి వెళ్ళిపోయారు. వాళ్ళు అసలు లేనే లేరు. ఫైనల్గా మేము వన్ బై వన్ డాట్స్ కనెక్ట్ చేసుకుంటూ వెళ్తే మాకు తెలిసింది ఏంటంటే కంపెనీ బోగస్. ఎవరైతే ఇందులో ఇన్వెస్ట్ చేశానని చెప్పారో అతను యూనియన్ బ్యాంక్ నేను కూడా చెప్తున్నా, యూనియన్ బ్యాంక్ని మ్యానిపులేట్ చేసి 4 crores తీసుకున్నారు. ఎక్కడ మాకు డౌట్ వచ్చింది అని అంటే, యూనియన్ బ్యాంక్లో మాకు తెలిసిన ఒక ఆయన ఉన్నారు. వాళ్ళకు కూడా ఈ కేసు పెండింగ్లో ఉంది అని తెలుసు. పలానా ఆయన ఈ కేసులో ఇరుక్కున్నారు, వన్ ఆఫ్ ద మేనేజర్స్ అని తెలుసు. వాళ్ళు మమ్మల్ని అడిగింది ఒకటే, ఎవరైతే బయ్యర్ ఉన్నారో నౌ హూ ఈస్ రెడీ టు పర్చేస్ దిస్ ప్రాపర్టీ నా దగ్గరికి రమ్మనండి, స్పాట్లో మేమే చేయిస్తాం. విత్ ఇన్ 1 hour లో మేము లోన్ డిస్బర్స్మెంట్ కూడా చేసేస్తాం.
బ్యాంక్ ఇస్ సో క్లవర్, ఐడెంటిఫైడ్ ద పర్టికులర్ ఇష్యూ.
సో మాకు అక్కడే డౌట్ వచ్చింది. అతను ఏమన్నాడు అని అంటే, బ్యాంకు వాళ్ళు కనుక నిజంగానే లోన్ డిస్పర్స్ చేసి ప్రాపర్టీ ఉంది అని ఐడెంటిఫై చేస్తే నేనే వాళ్ళ మీద కేసేస్తా రిటర్న్లో అని దొరికిపోయాడు.
చెప్తాను అన్ని డీటెయిల్స్ ఆఫ్లైన్ లో చెప్తాను.
నేను కూడా చేశాను, అందుకే అడిగాను.
ఆఫ్లైన్ లో చెప్తాను సార్.
అంతా అయిపోయిన తర్వాత మేము డాట్స్ కనెక్ట్ చేసుకున్న విషయం ఏంటంటే, అసలు ప్రాపర్టీ ఉంది అని చెప్పి తను ప్రూవ్ చేయాలి అని. ప్రూవ్ చేయాల్సింది ఎవరు? బయ్యర్ని తీసుకురండి. అసలు ప్రాపర్టీ తను చూసాడా లేదా, అతనికి అవేర్నెస్ కలిగిద్దామని ట్రై చేశారో, లేకపోతే ఇదేదన్నా మళ్ళీ ఫ్రాడ్ అని చెప్పేసి వీళ్ళని ఎత్తి చుట్టుకుంటుందన్నారో, బయ్యర్ని తీసుకురండి అని మాత్రమే చెప్పాను.
మా దగ్గరకు వచ్చినప్పుడు మాకు స్పెసిఫిక్ రిలీఫ్ యాక్ట్ మీద కేసు వెయ్యాలి.
మాకు అంటే వాళ్ళ కండిషన్ అన్నమాట, మాకు ఈ పర్టికులర్ దీనిలోనే వెయ్యాలి. ఏదైనా మనం ఇస్తాం సలహా, ఇలా వేయండి అని చెప్పి బ్రీఫ్ యాక్షన్ తీసుకొని మనం ఇస్తాం. మాకు ఇదే రిలీఫ్ కావాలి, మాకు ఈ రిలీఫ్ ప్రకారమే కావాలని వచ్చాడు ఫస్ట్ పాయింట్. 2 బయ్యర్. థర్డ్ వచ్చేసరికి ఈ క్రిమినల్ కేసుకి దీనికి ఏంటి కనెక్షన్ అని చూస్తే హీఈస్ ద ఫ్రాడ్. దట్ ఈస్ వాట్ క్వశ్చన్
మార్క్ ఈస్ వెరీ వెల్ సార్. కానీ ప్రాక్టికల్ వేలో అందుకనే అంటే బీయింగ్ ఎన్ అడ్వకేట్ మనం ఏం
ప్రాపర్టీ లొకేటెడ్ ఇన్ అల్వాల్.
మేము
వెళ్ళాం సార్ ప్రాపర్టీకి.
అవుట్
మేము అప్పటిదాకా ఒక ఎసర్షన్ తో వెళ్ళాం ఏంటంటే, ఈ ప్రాపర్టీ అసలు ఇతందేనా, అసలు ఈ ప్రాపర్టీ నిజంగానే ఎగ్జిస్టెన్స్ లో ఉన్నాయా లేవా అని చూడడానికి మాత్రమే మేము వెళ్ళాం. మాకు ఇచ్చిన దీన్ని బట్టి, షెడ్యూల్ ఆఫ్ ద ప్రాపర్టీని బట్టి, డాక్యుమెంట్స్ కూడా షెడ్యూల్ ఆఫ్ ద ప్రాపర్టీని బట్టి ఎగ్జాక్ట్లీ మేము వెళ్ళాం. వెళ్ళిన తర్వాత మాకు తెలిసింది ఏంటంటే, టోటల్ ఆ ఏరియాలో అల్వాల్లో ఉన్న ఆ పర్టికులర్ వెంకటాపురం సంథింగ్ ఏరియా మొత్తం లిటిగేషన్ లో ఉంది ప్రాపర్టీ మొత్తం. ఇతను చెప్పిన ఈ 2 ప్రాపర్టీస్ ఏదైతే ఉన్నాయో, ఈ 2 ప్రాపర్టీస్ ఓనర్స్ వేరే ఎక్కడో ఉంటారు, బెంగళూరు సంథింగ్. ఒకళ్ళు బెంగళూరులో ఉంటారు, ఇంకొకళ్ళు అసలు వేరే దీనిలో ఉంటారు. వాళ్ళ పేరు మీద వీళ్ళు జీపీఎల్ చేసుకొని వీళ్ళు ఎంత పకడ్బందీగా చేశారు అంటే, లీగల్ ఒపీనియన్ కూడా బ్యాంక్ నుంచి ఈ ప్రాపర్టీస్ మీద వాళ్ళు తెచ్చుకున్నారు. అడిగితే మేము లీగల్ ఒపీనియన్ కూడా తెచ్చుకున్నాము బ్యాంక్ నుంచి, బ్యాంక్ అథెంటికేషన్ కూడా మాకు ఉంది అని చెప్పుకోవడానికి బ్యాంక్ ఒపీనియన్స్తో సహా డాక్యుమెంట్స్ అన్ని రెడీగా పెట్టుకొని వాళ్ళు యూనియన్ బ్యాంక్లో 4 crores తీసుకున్నారు. వాళ్ళు ఇన్స్పెక్షన్కి రాలేదు. 4 crores
సస్పెండెడ్, నో డౌట్ అబౌట్. కాకపోతే మేము చేసిన ఇన్వెస్టిగేషన్ కి
నాకు ఫ్యూజ్ అవుట్ ఎక్కడైనాయి అని అంటే, అసలు ఈ ప్రాపర్టీ అతనిది కాదు. ఇది వెన్ ఐ వాజ్ ఇన్ ఇనిషియల్ డేస్ ఆఫ్ మై ప్రాక్టీస్ 2018 అది పేపర్లో వచ్చింది. అప్పటికి నేను ఇంకా ప్రాక్టీస్ కూడా స్టార్ట్ చేయలేదు. ఆయన మొత్తం పర్టికులర్ ఏరియా ప్రెసిడెంట్ చూపించి దిస్ ఈజ్ వాట్ ద సినారియో. నేను గ్రూప్లో కూడా ఆ ఫోటో ఒకటి షేర్ చేస్తాను, నాకు వచ్చిన పేపర్ కటింగ్ ఇప్పుడు ప్రజెంట్ లేదు, నేను షేర్ చేస్తాను. సో మేము అనుకున్నాం, బాబాయ్ ఈ క్లయింట్ మమ్మల్ని బుక్ చేసి ఉంటే 4 కోట్ల బుక్ చేసేవాడు. వి షుడ్ బి బిహైండ్ ద బార్స్.
లేదు సార్,
మేము ఎందుకు అవుతామని వాళ్ళ ఆప్షన్ ఏంటి సార్ మనకి?
స్పెసిఫిక్ రిలీఫ్
స్పెసిఫిక్ రిలీఫ్ యాక్ట్ కిందకే రావాలంటే మనం ఏం చేస్తాం సార్?
యు ఆర్ రిప్రజెంటింగ్ ద కేస్. హౌ యు ఆర్
representing it.
సార్ మనం ఆథరైజ్ చేస్తాం కదా, కొన్ని డాక్యుమెంట్స్ మనం ఫ్యాబ్రికేట్ చేస్తాం కదా, మన దగ్గర ఉన్న చాలా పెద్ద
అకార్డింగ్ టు ద
అడ్వాంటేజ్
డాక్యుమెంట్స్ దే ప్రొడ్యూస్డ్ వి హావ్ డాక్యుమెంటెడ్. వాళ్ళు ఇచ్చిన దాన్ని బట్టి మేము చేస్తాం, కానీ ప్రతి దానికి వెళ్ళి మేము ఎత్తుకుంటూ పోయి చూడం
మీరు
కదా.
అన్న పాయింట్ కరెక్ట్. మనం కూడా కొన్ని చేస్తాం కదా.
చేస్తాం. దట్ ఇస్ డిఫరెంట్ మేడం. దట్
పర్టికులర్ కేసులో చెయ్యకపోతే రన్ అవ్వదు.
ఇప్పుడు ఒకటి మాకు చెప్పిన దాని ప్రకారం బినామీలు అని చెప్పినప్పుడు మనం ఏం చేస్తాం సార్? ఏ అగ్రిమెంట్ మన దగ్గర ఉందనో, ఏ జీపీఏ మన
వాళ్ళని
దగ్గర
తెచ్చుకోమనాలి.
ఉందనో
క్రియేట్
మనం ఎందుకు చేస్తాం సార్? క్రియేట్ చేస్తాం అంటున్నారు, నేను చేస్తానని చెప్పడం లేదు.
అకార్డింగ్
ఒక
టు ద
సజెషన్
రిక్వైర్మెంట్,
ఇస్తాం కదా,
అకార్డింగ్ టు రిక్వైర్మెంట్ మనం క్రియేట్
సజెషన్
చేస్తాం.
ఇస్తాం కదా.
వాళ్ళు ఏమంటే మేము చేసాం మాకేం తర్వాత అంటారు.
ఇక్కడ
నీ బుద్ధి ఎక్కడ పోయింది?
Final గా ఎవరు
నీ బుద్ధి ఎక్కడ పోయింది అని అంటారు. నీ బుద్ధి ఎక్కడ పోయింది? వాడు ఎన్నన్నా చెప్తాడు.
లేదు లేదు సార్,
ఇక్కడ ఇంకో జరిగింది.
బ్యాంకింగ్ లో ఉన్నాను.
లేదు సార్,
నాట్ దట్ వే ఇట్ రన్స్.
నేను బ్యాంకింగ్ ని మాట్లాడలేదు
కాదు,
సార్.
కాదు.
నేను బ్యాంకింగ్ ఫీల్డ్ అసలు మాట్లాడలేదు.
నేను బ్యాంకే సార్. నేను ఆ డాక్యుమెంట్ చూసిన
He's
తర్వాత
also from
ప్రతి
bank.
డాక్యుమెంట్, ఎవ్రీ స్టెప్ ఆఫ్ ది డాక్యుమెంట్ ఈస్ సో క్లియర్, యూ విల్ సే దట్ ఇట్ ఈస్ ఎగ్జిస్టింగ్. ఆ డాక్యుమెంట్ లో ప్రాపర్టీ ఎగ్జిస్టింగ్ అని అంటారు, ఇంక్లూడింగ్ ఈసీస్. హి హస్ ఫ్యాబ్రికేటెడ్ ఈసీస్ ఆల్సో.
దిస్ ఇస్ ఆల్సో దేర్. ఎంత పకడ్బందీగా ఉన్నారన్న దానికి
అంటే అంత ఈజీగా ఫ్యాబ్రికేట్ చేసి పెట్టారు డాక్యుమెంట్.
బ్యాంక్ లో ఎగ్జాంపుల్ లీగల్
Sir,
ఒపీనియన్
let us,
మనం ఒకటి పబ్లిక్ సెక్టర్ బ్యాంక్ లో సబ్సిడీ తీసుకుంటాం.
Mr. Srikanth, let us,
సార్
Yeah, come to the point, sir.
We have a break.
I'm having, 1 minute, I'll finish this question. See, continuing from where we left,
సార్ ఒక చిన్న కన్క్లూజన్ మీరు లెఫ్ట్ మీరు కానీ
where
ఐ రిక్వెస్ట్ ఎవ్రీబడి, ఎవరున్నా ఇంతమంది, ఓ చిన్న మీకు వస్తే ఖచ్చితంగా మీకు డౌట్ వస్తే, యూ ఫీల్ ఎ డౌట్ ఇన్ ద పర్టికులర్ సూట్, ప్లీజ్ గో అండ్ ఇన్స్పెక్ట్ ఫస్ట్. ఇప్పుడు వచ్చేవన్నీ కూడా ఇలాంటివే వస్తాయి, పర్టికులర్ కేసెస్. గో అండ్ ఇన్స్పెక్ట్ ద సైట్. సైట్ ఇన్స్పెక్షన్ ఇస్ మ్యాండేటరీ అని మీరు పెట్టుకోండి. కొన్ని విషయాలు మీకు డౌట్ వచ్చిందంటే వెళ్ళిపోండి.
see, sir, 1 minute, sir, let us.
We will share it out.
See, we were dealing with injunctions. Injunctions, there are 4 types. One is called interim injunction, another is called temporary injunction, another is called mandatory injunction, and yes, a perpetual injunction. As far as interim injunction is concerned, interim injunction is governed by the Civil Procedure Code or a 39 Rule 1 and 2. Here, interim injunction doesn't mean injunction forever. It means for a limited duration of time, and the other side files a counter, then both of you are heard and the court passes an order. And one basic thing you must remember is, when you are arguing an IA, according to the High Court circular, whatever documents you have filed in support of your claim, you have to get those documents marked first before you submit your arguments. Why? Because it's to enable the court to appreciate your document and decide the case accordingly. The court also has to mark the documents before hearing the arguments. That is a must and compulsory and mandatory. Then, once the interim injunction is heard by both the sides, on both sides, the court converts it into, suppose you succeed in convincing the court or confusing the court allows your application, the interim injunction gets converted to temporary injunction, and the temporary injunction remains in force till the disposal of the suit. And temporary injunction is filed under Order 39, Rule 1 and 2, CPC. Am I making myself clear to you, please? Then, after that, you got, once the evidences are laid on both sides, documents are filed on both sides, arguments are heard, then the court decides the issue, the temporary injunction gets converted into perpetual injunction. So, there are 3 stages. One is interim injunction for a limited duration of time governed by CPC, temporary injunction after hearing both the sides as far as your interlocutory application is concerned. Interim injunction gets converted to temporary injunction and remains in force till the disposal of the suit. Then, once evidences are laid on both sides, arguments are heard, the temporary injunction gets converted into perpetual injunction. That is an injunction forever, or a restraint order forever. It is also called a preventive relief, or it's called a prohibitory relief as per law. Then mandatory injunction, as far as perpetual injunction is concerned, it promotes what is called inactivity. not to do a particular thing, that's all. Inactivity. But mandatory injunction is where you ask for positive enforcement, where you want an order to be passed in your favor to do what you have not done. Suppose this road is blocked. Let us say someone constructs on that road. That's what Hydra is doing it. On a lake, you try to encroach, or on a public road, you try to encroach. Those encroachments can be removed only by directing the other side to get alert, or the authority to get alert and do what they have not done, or promotes activity. That is what is called mandatory injunction. Perpetual injunction promotes inactivity, but mandatory injunction promotes activity. In constitution, we call it as mandamus. What you have not done, what the authority has not done, the court orders or commands the other side to do that particular thing which it has omitted to do. That is what is called mandatory injunction. The word mandatory itself comes from the word mandate. Mandate means command, or do what you have not done. At least do it now. That is called mandatory injunction. But the basic principles are almost the same. Prima facie case, balance of convenience, and relative hardship. And the first earliest case decided on the law of injunctions was 1963, AP 365. The judgment rendered by Justice P. Chandra Reddy and Justice Sesha Chalapati, which has been followed by all the courts, including the Supreme Court. These three basic ingredients cannot be dispensed with. And one thing is, once you want a discretionary remedy, you will have to come with clean hands. You shall not suppress any material. You shall not conceal any material. You shall not hide any material. You must come something like what is called Caesar's wife. Your character should be above board. And one who seeks equity, suppose it is said, jocularly it is said, kettle calling the pot black. Kettle itself is black. Just, అరే ఎంత నల్లగుందో చూడండి పాట్ అంటే నువ్వే నల్లగున్నావు వాడు నల్లగున్నావు నువ్వు ఎట్లా చెప్తావు అని. So question is, you shall not suppress any material. When you want equity to step into your case, and you must also do equity. You must also be prepared to perform your obligations. Without performing your obligations, you cannot say that the other side is at fault. Any suppression, any concealment, any hiding of any facts does not entitle you to get an order for injunction. So a judgment for mandatory injunction, judgment for perpetual injunction is what is called a judgment in rem. It operates as far as the entire world is concerned, not only you, but others also. That is 37, 38, 39. Then the last section, the specific relief act, is section 41. What are the reliefs that cannot be granted? First of all, I think my friend here, suppose let us say, of course I don't do it, suppose she wants to file a criminal case against me for forgery, or she wants to file a case against me for, let us say, defamation, etc., etc. Then in that case, I cannot stop her from saying, don't file a suit against me, don't initiate criminal proceedings against me, don't go to a criminal court, or don't initiate FIR, don't initiate investigation, don't file a criminal case at all. Please remember, I cannot do it. I cannot file such a suit and ask for an injunction. Right? Second thing is, I cannot prevent the others, cannot take an injunction preventing the other side from initiating civil proceedings against me, against you. The question is, such an injunction cannot be granted. Or suppose an injunction is to be obtained to what is called, let us say, the question is, in respect of an agreement which is contrary to public policy, then in that case, injunction cannot be granted. So section 41 enumerates various instances where injunction cannot be granted. That is the negative aspect of that particular section. Here, as far as cancellation of instruments and decrees are concerned, declaration suits are concerned, period of 3 years is mentioned. Article 58, Article 59 says within 3 years it has to be filed. And please remember, though you have got the right, you don't have a remedy. You cannot knock at the doors of the civil court once it's barred by limitation. Are you able to follow this?
So we'll have a break.
So these are the various facets. Of course, I'm not saying my lecture is exhaustive, but if you see my Dharma Legal YouTube channel, I've got exhaustively on all these aspects. Kindly go through it and try to gather your own facts and gather your own knowledge. And please remember, every day we are a learner. We learn things, new things every day. No one can say I'm perfect. I am also not perfect. Please remember, those days we didn't have so many laws as you people have today. Please remember, మీకు తెలవకపోతే చెప్పండి, నేను ఇంటికి పోయి చూసుకొని చెప్తానని చెప్పండి. రాంగ్ ఇన్ఫర్మేషన్, రాంగ్ అడ్వైస్ ఇవ్వమాకండి. So that finishes the specific relief practice.
We'll meet after lunch at 3 o'clock.
Pardon? Pardon?